Welcome to the Office of Special Counsel's video series on prohibited personnel practices. Please be sure to visit our website at www.osc.gov to view the full series of videos. In this video, we will discuss the prohibition on implementing or enforcing a non-disclosure policy, form, or agreement that fails to notify employees of their statutory whistleblower rights. This video will also discuss the prohibition on chilling whistleblowing in the federal workplace. The prohibited personnel practices that we have discussed so far were all part of the Civil Service Reform Act of 1979. Title V of the United States Code Section B13 was added later as part of the Whistleblower Protection Enhancement Act of 2012. The purpose of Section B13 is to strengthen whistleblower protections by requiring agencies that have non-disclosure policies, forms, or agreements to make it clear to employees that they still have the right to make protected disclosures and engage in protected activity, even if they are subject to a non-disclosure policy or agreement. This is important because an employer applicant who signs a non-disclosure agreement may think that it means that they are unable to speak up if they see evidence of waste, fraud, or abuse. But that is just not the case. Employees have the right to blow the whistle and engage in protected activity, and these rights cannot be taken away by an agency's non-disclosure agreement or policy. To make sure employees and applicants understand their rights, Section B13 requires agencies to include a statement in any non-disclosure policy, form, or agreement clarifying that employees' whistleblower rights supersede any agency restrictions on disclosures. Section B13 is also significant because it prohibits agency officials from engaging in practices or making statements that could serve to prevent or discourage whistleblowing. Some examples might help to show the importance of Section B13 and how it applies to different situations. For that, I'd like to bring in an OSC attorney who investigates these types of prohibited personnel practices.
An agency might ask people serving on an interview panel not to talk about the questions asked in the interview, candidate scores, or internal deliberations. And it's okay for an agency to do that to prevent candidates from finding out questions in advance or stop employees from gossiping about how candidates performed during the interviews. But what if something happens during the hiring process that is unlawful? For example, what if an interview panel member learns that one of the candidates is another panelist's child, and that panelist did not recuse themselves from the interview and gave their child a high score? If the non-disclosure agreement does not contain the information required by Section B13, the employee might think that they can't say anything because they would have to share information about the interview process and scores to report the nepotism violation. This is a problem for the panelist and all the candidates who did not have a relative helping them in the hiring process. It's also a problem for the agency because it will not know that nepotism took place and might hire the panelist's child not knowing about the unfair advantage they received. But if the agency's non-disclosure agreement includes the clause required under Section B13, then employees will know that the right to blow the whistle overrides the agreement. The information can come out, and the agency can address it before the problem becomes worse. Agency officials should remember when they communicate with employees or applicants that they should not do so in a way that might chill lawful whistleblowing. Yes, OSC had a case where an agency official told his staff not to communicate with auditors from the agency's Office of Inspector General because they all needed to speak with one voice. The agency had to rescind the email and send another one to employees, informing them of the right to communicate directly with the Inspector General. Not when it comes to protected disclosures. Except where required by law, whistleblowers do not have to make disclosures through any one channel. There are many permissible ways for a whistleblower to make disclosures, including OSC, the Office of Inspector General, agency leadership, outside agencies, Congress, and the media. Some information, including classified information, must go through specific channels. An agency can inform employees of these restrictions, but it should be careful not to suggest that employees are limited in where they can go with other disclosures.
Thank you for that helpful information. For more information about the anti-gag order provision, including a memo by the Special Counsel explaining this topic in more detail, please access the other resources on our website.